Constitution is on report.
Good afternoon. Please be seated. We have one case on the docket today. It's cause number 14-22-00388. If council would make their appearances for the record.
Good afternoon. Scott Novak on behalf of the appellant, Transportes de Zima Real, S.A. de C.V.
Josh Willier on behalf of the appellees, Clementina and Maria Benitez.
And would you like to save some time for rebuttal?
Yes, thank you, Chief Justice. 10 minutes for my first argument, 5 minutes saved for rebuttal.
Okay. Get the timer ready to go. All right. We're ready when you are.
Thank you. May it please the court. My name is Scott Novak, and I am here representing the appellant, Transportes de Zima Real, S.A. de C.V., a Mexican corporation operating in the country of Mexico. I'd like to introduce this case with a quote from Asahi Mills. The unique burdens placed upon one who must defend oneself in a foreign legal system should have significant weight in assessing the reasonableness of stretching the long arm of personal jurisdiction over national borders. This case presents questions regarding the framework of personal jurisdiction relative to a foreign defendant, as well as questions of due process of the law. During my time, I'd like to make 5 simple points to the court. 1, the operative facts of this case are not about ticket sales or about de minimis relationships with the state of Texas. They are about a crash that unfortunately occurred in Mexico. Questions that will be answered by a jury, by a trier of fact, will relate to whether or not Transportes, their drivers, their training, their maintenance of their vehicles, which all took place in Mexico, met the standard of care relative to those practices. Nothing pertinent, nothing operative to this case occurred in the state of Texas. That is point 1. There is no indication that the appellees were even aware that there was a relationship between these companies when they purchased their tickets in Mexico. Another fact that should be considered is that the transaction that we're talking about today occurred in Mexico. Under Moki Mac, this is not a case of specific jurisdiction. Basically, the operative facts are centered in a foreign country, which has a greater interest in adjudicating this matter and would lessen the burden placed on this foreign defendant. Secondarily, Transportes structured its business, particularly with Zima Real Bus Lines, a Texas corporation, to avoid availing itself to Texas law and to avoid entering the state of Texas to do business. While it had an arrangement, its arrangement was formally designed to stop at the U.S.-Mexican border.
Does the record reflect what the corporate structure is between Transportes and Zima? That is, who owned them? Are they sister corporations? Does the record reflect that?
I would not refer to them, Your Honor, as sister corporations. There is an arrangement between the two, but I don't believe the record reflects there being cross-pollination in terms of management.
Well, there is cross-pollination in terms of management. I was asking about ownership.
No, I don't believe there's anything reflecting the record in terms of cross-pollination of ownership. They are run as completely distinct companies. There is an organizational chart which describes the Mexican company that is in the record, but to my knowledge, there is not one reflective of the U.S. corporation.
Except we have one common director, right?
Well, there's a gentleman named Vicente De La Torre that I believe has a name similar to the a gentleman that appears on the organizational chart as sort of an administrative person. He's lower down on the tier underneath the governing head of the company, but it is unclear if that is the same Vicente that appears on the org chart that is reportedly living in San Antonio. Now, whether or not he is reflective of or involved in Zima Real is not clear from the record. The plaintiffs in the case, the appellees, did not meet that burden of establishing that level of commonality. Additionally, I believe it's fairly clear that the corporate rep for the Mexican company Transportes testified that, to his knowledge, the Vicente de la Torre that was related to Transportes did not reside in San, although there is a Vicente that does. As I said, the second point is that Transportes structured its business to avoid entanglements in Texas. The record is clear that in order to facilitate the transport of passengers, Transportes brought passengers on its own buses to the border. They either deboarded the bus and got upon a bus that was run by Zima Real and driven into the Texas interior, or a bus would be leased, or part of a lease agreement, where one of these buses would have entered the Texas state vis-a-vis a Zima Real bus driver, not a Transportes bus driver.
Well, in this case, the bus in question from Mexico was going to cross the border into Laredo, was it not?
The corporate rep denied that. He said this was not part of the lease program. This particular bus that the two Benitez plaintiffs were on was not part of the lease program.
All right, so it was going to stop in Mexico?
That's my understanding. This would have stopped in Mexico. The parties would have deboarded, they would have boarded another bus, and they would have entered Texas. This case is distinguishable from one of the appellee's primary cases, which is the Summit Machine and Tool versus Warren case, Southern District matter. That case, which found a more general jurisdiction related to cross-border involvement of a Mexican corporation, involved thousands of transactions that occurred over the border. In effect, when we're speaking about Transportes, there's no way to connect the level of involvement that the corporation in Summit had compared to what Transportes did. Transportes had very limited contact with Texas, and that contact was simply designed to facilitate transport up to the border. This case, this court in particular, has previously looked at this exact company in the Lizarraga matter and found no specific jurisdiction based on the arrangement that was described in that case that was also in effect in this case. Number three, and this is to reiterate, in practice, Transportes did not enter the state of Texas beyond the free trade zone or the international bridge. As I said, passengers deboard and board a Zima Real bus, or a Zima Real bus that is being leased from Transportes is driven into Texas by a Zima Real directly. Fourth, as we're speaking about more broad jurisdictional questions, general jurisdiction, because I think specific jurisdiction is easily done away with in this case based on the operative facts, the trial court seemingly found a level of general jurisdiction based on minimal or a degree of contact with Zima Real that was founded on a course of essentially innuendo and conjecture about what unauthenticated and unproven evidence presented by the appellee's counsel supposedly found. There was an argument of commonality of advertising, but it was not established through any formal or authenticated means.
Well, what difference would it make if those exhibits were admissible?
I'm sorry, Chief Justice, I think that that's a critical aspect here that well, I think for one, it probably doesn't make that big of a difference because some sort of passive common joint venture, I wouldn't say joint venture, but some passive common joint advertising, just informing people on a Facebook page, probably doesn't reach the degree of pointed marketing towards the forum state. But in this particular case, there is no indication that that Facebook page, the online marketing that was shown to the Transportes corporate rep, in fact, was being managed or even approved by Transportes. It was perhaps something that was created by Zima. There was only a singular website affiliated with Transportes, and it was a Mexican URL. None of those documents, however, were authenticated, so to the extent the trial court considered them, that would be.
Well, in this case, Transportes sold the ticket for both the Mexican and the United States leg.
Yes, just like an interline agreement, exactly like an interline agreement. where a flight is sold with multiple legs of travel, and that the companies that handle those various legs of travel have a true-up. That does not expose a foreign corporation to general jurisdiction within the state. In this particular case, it would be a fallacy to consider Transportes at home in the state of Texas. They're very much a Mexican corporation who does not do business here, does not maintain offices here, really does not have officers here, and really has there's no evidence of any significant property. In fact, the one piece of property that the appellees have cited to were some 2017 registration of some buses purportedly owned by Transportes, clearly before the loss that we're talking about today, and subsequent tax filings or Secretary of State filings had none of that connection to Transportes. I suspect those were probably Zima Real filings indicating the title holder of those buses.
Was there any testimony from the plaintiffs that they saw the Facebook or the posts or the website?
No, and I think that's an important aspect of this case. While it is argued in appellee's briefing that some of their decision making was related to the relationship between Transportes and Zima Real, there's nothing to substantiate that. As far as the facts go, I would leave the court with this impression for my rebuttal time that the tickets were purchased in Mexico at a Mexican ticket sales stand, and there really is no indication as to why the two Benitez plaintiffs chose to use this particular service.
Okay, thank you.
May it please the court. Appellees want to make perfectly clear one point at the outset, that they are not asking this court to overrule its own precedent. Appellees are aware that there was a 2014 opinion concerning the same defendant under this so-called interchange agreement. We understand that Justice Christopher, you may have written for that opinion, and there are some factual differences between that opinion and this case that are extremely important that I'd like to talk about.
You took my first question out of my mouth.
And the reason why that case is different from this one is because there are two factual differences and then a conclusion that we can draw from those facts. The first factual difference is that this bus was going to disembark its passengers on the Texas side of the border. Justice Wilson, you asked whether or not they're going to disembark the passengers in Mexico, in Nuevo Laredo, or in Texas, in Laredo, Texas. And the answer from the corporate rep's deposition is clear on that point at 297 and 293 of the record. Specifically on page 297, he says that specific bus had permission or permits. It will cross passengers over all the way to the customs entrance, that's in Laredo, where they disembark. That is in the Texas side of the border, and so that's difference one. Whereas in the 2014 Lizarraga opinion, it was noted that the bus at that time would disembark its passengers in Nuevo Laredo on the Mexican side of the border, and at no point would a Transportes bus or employee enter the United States or enter Texas. So that's the first point of distinction that's important to note. The second point of distinction that Lizarraga has between this case and that case is that the plaintiff in Lizarraga was not a Texas resident, or at least there's no evidence that he was a resident, nor was he, according to the record, traveling anywhere in Texas.
How do either of those two differences relate to specific jurisdiction?
The reason why is because the plaintiffs in our case purchased one-way tickets from Cuetamo, Mexico to Houston, Texas on a single fare. It wasn't two tickets, it was one ticket from Transportes. And so from those facts, we can conclude that Transportes contracted for common carriage of two Texas residents with partial performance in the state of Texas when they crossed the border into Texas to drop them off at the customs entrance, disembark, and then enter that Zima Real bus on the other side of customs. And so under those circumstances, we've satisfied the long-arm statute, requires having part performance of a contract in Texas. We also have some evidence of there being employees or managers of Transportes individuals in the state of Texas, and so prong one of the test of personal jurisdiction is the long arm satisfied? Absolutely is. Part two on specific jurisdiction, we've got to ask ourselves, did they purposely avail themselves of the privileges of doing business in the state? And the corporate representative's testimony is yes. And the reason why is because he expressly testified. We got permits and permissions to drive all the way up to the border and drop off our passengers on the U.S. side of the border before customs. This is not this case, but they have other buses that have special permissions that can drive all the way up to the 27th mile in the border and turn around and come back. And so he made that distinction clear too. And so they have, in the same line of business of common carriage of passengers from Mexico to Houston, have been dealing with the state and with the federal government in order to allow them to do that, to facilitate that business for their own economic advantage, and are no longer apparently dropping passengers off on the Nuevo Laredo side, of the Mexican side of the border in Nuevo Laredo. And so that being the case, we have both long arm, we've got purposeful availment, and so the only thing we got to look at then is relatedness under the Moki Mac case and the recent Luciano case in 2021. And I think the reason why we've got relatedness here is, for one, in 2021 we learned from the Texas Supreme Court's opinion is that that standard for arising out of or related to is looser than we had anticipated before that opinion. It's not a strict causation approach. It is one of two things. It can either arise out of the transaction, the injury causing incident. I think the phrase is the actionable conduct.
But the facts in Luciano are very different in terms of targeting the Texas audience.
That's a stream of commerce product case, but if we substitute goods for services, it's a similar situation, because in this case, Transportes is targeting Texas individuals for its services of transportation from Mexico to Texas and vice versa. And in that way, it's a similar sort of situation to the Luciano opinion's product case, which was about spray foam, I believe, Judge. Mm-hmm. And the Luciano opinion also makes reference to Azteca TV opinion, Texas Supreme Court, which had to do with defamation, and that was about broadcasting defamation over Texas airwaves and receiving that information. So we can actually, what that teaches, that we can draw those same lessons about stream of commerce and targeting the residents of the state in the same way as a product case is a case about services or in a case about broadcasting.
But the big problem that you have is that the accident happened in Mexico.
That's right, Judge.
You know, if the accident had happened, in those two cases, the injury happened in Texas. No injury in Texas here.
Sure.
You know, maybe if the injury had happened on the Texas side of the border, you'd have a better case. But just the fact that it was going there, I'm not sure that's enough.
So that's a good point, Justice Christopher, and I think the reason why we still have jurisdiction in this case is because we know that had this accident not occurred, this bus would have entered the state of Texas and would have disembarked on the Texas side of the border. And so they are purposefully targeting Texas and entering Texas for an economic advantage. That's difference one. The second thing is that if you're looking at it from...
But then that's still in the dead zone, though, right? That space on the border goes for a certain number of miles, and it's a different set of rules as to whether people from, you know, a truck from Mexico can get into that dead zone, whatever it's called.
I think it's called the Free Trade Zone,
right,
Your Honor, and,
right.
And we cite in our brief Summit versus Warren, a case out of the Southern District of Texas, and I believe in that opinion, the federal judge there said, regardless of whether it's a part of the free trade zone is in Texas, it is still Texas. And so from that, I think that you can draw the conclusion that it really doesn't matter whether or not it's an ostensible free trade zone or not, it's still on Texas soil. And so here's a hypothetical that I think makes this point clear. If the bus had rear-ended a vehicle in front of it across the border bridge, but before customs, I think that that's a pretty easy case that we would have jurisdiction because the tort would have occurred in Texas. And so if we draw the...
like Luciano and the other one, you know, the tort occurred in Texas. You don't have the tort occurring in Texas here.
And so what Moki Mac and Luciano teach is that when the actionable conduct occurs in Texas, then the additional conduct of targeting Texas does not have to, it does not have to arise out of that conduct.
Well, what actionable conduct took place in Texas?
So the actionable conduct, Judge, is the bus crash. But the additional conduct...
What actionable conduct took place in Texas?
So what we're saying, Judge, is that the rule should be that the actionable conduct, if it occurs outside of Texas, like in Moki Mac, then what you need is some relation between the actionable conduct out of state and the in-state conduct, the targeting. And in this case, we have a solicitation of Texas residents for a one-way bus trip from Mexico to Houston, and agents in Texas to facilitate that network, that transportation network. And you've got a common carriage situation where they're taking on duties to safely transport those customers from Mexico to Texas. Then the actions in Texas, including crossing the border to disembark the passengers, are related enough to the actionable conduct that's out of state that you meet the relatedness prong under Moki Mac. Because recall in Moki Mac, the reason why that case was not related was because the actionable conduct all occurred on a hiking trip in Utah, not on the solicitations or the advertisements in Texas. This case is different, and the reason why is because the solicitations, the targeting, all relate to the common carriage, the voyage from Mexico to Texas. And so you have a situation where even when the actionable conduct occurs outside of the state, that
But at Moki Mac, didn't they even have a bus that came from the camp to take them from Texas to the camp? I mean, there was a lot of contact with Texas in Moki Mac, and the Supreme Court said no.
There were, and I think that the reason why that case didn't meet the relatedness prong was because of the fact that the negligence itself happened on the hiking trip, not on the transportation. Whereas in this case, it's all about the transportation. Everything.
But the injury is still on the Mexico side, right? So and the tickets were bought in Mexico. So
Yes, Judge.
beyond, I mean, so is the only way that we can connect this to Texas because you're saying that they marketing wise targeted them to come into Texas and the bus was supposed to cross the border?
So yes, that is one of the major differences, is that this bus was going to cross the border into Texas during that part of the journey, and partial performance of that contract would have been performed in Texas.
Did your clients testify about anything in connection with why they bought this particular ticket?
So the reason why, this case has languished for quite a bit on the docket, but our clients never were presented for deposition, and we wanted to get past this initial stage of trying to figure out this jurisdictional question first. So what we have in front of us, admittedly, is a pre-trial and relatively early stage record. Once this issue is resolved, I expect that one way or the other, we still have a live defendant in the Zima Real Bus Lines entity, that the clients will be, my clients will be deposed, and that will have a fuller record. But at this point, we still have a relatively undeveloped discovery record on those points.
Well, you could have submitted an affidavit from your clients.
Yes, Judge, but the reason why we didn't do that was because the Texas Supreme Court has made clear that the subjective mental state and the intentions of the plaintiffs isn't what you're looking at in a personal jurisdiction question. What you're looking at is the defendant's actions, and whether or not the quality of the defendant's contacts with the state is what matters. And so for that reason, we didn't think that that would be a fruitful exercise in creating evidence and cross-examination fodder, etc. Very briefly, I think I've talked about the specific jurisdiction point quite a bit. I'd like to just briefly talk about the general jurisdiction issue. The vehicle to get there, and again, this is a pre-trial record on this issue, is that our pleading here is that it's an alter ego theory against both of these companies. Justice Wilson, you had mentioned, or you'd asked about the relationship with these two companies, and it's opaque. We don't know, other than this interchange agreement, except that it's clear that this is a symbiotic relationship. One does not exist without the other, because one relies on the other for transportation from, on one side of the U.S.-Mexican border and the other side of the Mexican border.
They both have the same name in their corporate names. And there's obviously some relationship, but we don't know what it is.
And we know that there's a common stakeholder. Vicente Vasquez de la Torre is apparently the majority shareholder of Transportes. He's also the president of Zima Real Bus Line, the American entity. In the briefing and in some of the Spanish language documents, they have said that he has executed some kind of power of attorney in favor of the current president of Transportes. However, there is no indication that he's given up control over Transportes. Moreover, the current president of Transportes was, and for purposes of this litigation, was served with the process because he was a registered agent of the American entity. And so clearly there are some relationships between these companies that have lasted, and their excuse for why service on Transportis President effectuated service on ZRBL, Zima Rail Bus Line, the answer is I don't know. I don't know why I was the registered agent. And so part of that is the lack of documentation, the dearth of, or the opacity with which this corporate relationship has been presented to us in discovery.
But it was your burden at this point, if you're trying to prove general jurisdiction.
Sure.
You're trying to prove that they're alter egos.
And I think what we have done is shown that there is evidence of failure to have arm's length relationship between these two companies, that there is a failure of documentation of the transactions for purposes of revenue sharing, that there's common ownership and managers in the state of Texas, as well as this joint advertising and joint representation of the companies one and the same, including having the Transportis on one side of a handbill and Zima Rail Bus Line on the other side of a handbill and distributing that out as marketing material. They're representing themselves to the community as one and the same company. And for that reason, we think that the trial court made the right decision by inferring the relevant facts that these are one and the same companies, that they're alter egos, and the evidence supports those conclusions, and therefore the court can credit that favorable testimony to the trial court and disregard the self-serving affidavit testimony of Transportis declaration, which many of those facts were contradicted by the corporate representative's deposition testimony in any event. And so for those reasons, we believe that the specific jurisdiction is met because all three prongs of that test are met. We think that the general jurisdictional question, even though on this record it's a bit more difficult and it relies on circumstantial evidence, we think the trial court came to the right conclusion on that, and that it would not be unfair for Texas courts to exercise jurisdiction because of all the reasons that we've already stated.
Thank you.
Thank you, Your Honors.
I'd like to cover a couple of the things that were discussed in my colleagues' statements, but I don't want to retread things that are already covered in our briefing. Most of those points have already been made. With regard to the registered agent issue, there was testimony about the fact that this gentleman didn't know he was left on as a registered agent for Zima Real. He had previously worked for Zima Real, left that company in 2018 before the accident, believed that he had been taken off but wasn't. And besides, there's case law from this court under Connor indicating that having a registered agent within the state anyway does not effectuate an agreement to be bound by their jurisdiction. In addition, this would have been for Zima Real. This gentleman no longer works for Zima Real. He is the head of Transportis, located in Mexico. I'd also like to point out some of the key differences. Summit Machine and Tool versus Warren was brought up extensively by my colleague, and I'd like to point out that the involvement of that Mexican company in the state of Texas went far beyond simply going into the free trade zone and dropping off materials. That company actually had a license to do business in Texas. It, in fact, arranged for contracts in Texas where things would be picked up and stored and dropped off with Texas companies. It transported over 1,700 loads of cargo across the border in a 4-year period, and 2,000 to 3,000 shipments to a Texas company into the interior. They were regularly doing business with a Laredo-based company, including receiving shipments, soliciting business, and forming contracts, as well as buying equipment in Texas. None of that applies with regard to Transportis. I'd also like to address this issue about the bus. Recalling, of course, that this deposition that was taken of the Transportis corporate rep was in Spanish. There's a little bit of a translation issue that we contend with, but if you read his testimony in context, in conjunction with the sworn statement that was provided to the court by Mr. De La Torre, it's very clear that this bus was not intended to go into Texas. That buses that go into Texas are subject to the lease agreement, and they brought into Texas, if at all, by Zima Real drivers. I can't say with 100% certainty that a bus isn't turned around at the customs gate. That may happen, but I think that the point of all this is that Transportes makes every effort not to entangle itself within the United States, within the state of Texas. As for the alter ego,
Mr. Lee says the evidence shows that this bus was gonna go into Texas.
I challenge anyone to point to anything in the record that says that with any sort of clarity. The way that the corporate rep described this, if you look at the context of the testimony, and I believe it's primarily at CR 297, and then also comparison to the Jose Manuel Vasquez de la Torre declaration at CR 171. And those are the general areas of that testimony: CR 170, CR 171, as well as CR 168.
Well, you said that Transportes purposely intends not to do business in Texas. Mr. Lee points out that some of its buses were licensed to go into the free trade zone, and some were licensed to go 20 some odd miles into Texas. So to some extent, they were doing business in Texas.
I think that there's a little confusion. The free trade zone is that 20-something miles. That's the loop that we refer
I
to
thought
as the
it,
free
I thought
trade
it was
zone.
much narrower.
No, it's quite a bit larger than that, actually. It's about 25 miles on each side, is from what my understanding is. And to be frank, while the vehicles are licensed to travel into the state of Texas, they're only licensed pursuant to the international interchange agreement between these companies and the lease agreement to be operated by Zima Real drivers past that free trade zone. So that is again, what my point being, it's not that Transportes is particularly not doing business with a Texas corporation. There's no denying the fact that they have a relationship with Zima Real. The point is they're not availing themselves to the state of Texas. They are not seeking the protections of the law of the state of Texas or benefits from the state of Texas. Their focus is to facilitate transport up to the border where another company travels into Texas with passengers. And that is very common in terms of drayage type arrangements with cargo, and interline agreements with airlines, and interchange agreements like with this company, Grupo, and other matters that are cited within our briefing. But the point is that the burden was on the appellees in this case to establish not just general jurisdiction, but also if their position is that these are alter ego companies, they have not met those burdens. To say that Texas is a home for this company is a stretch, a very, very long stretch. And to say that they are in fact alter egos without any evidence of control or commonality between these companies is a fallacy. And while I certainly respect the trial court's decision, the trial court was presented with a lot of things, the material that was presented to the trial court does not push this horse over the line.
All right, thank you. Thank you for your excellent arguments. The case of Transportes v. Benitez is submitted and we are adjourned.
Thank you, Chief Justice.
All rise.